Welcome to another session on CL4 corporate law, where we discuss about the law relating to companies or corporations, specifically touching upon the Companies Act of Sri Lanka. Now, last time I was explaining to you, and where we stopped was on the area of oppression and mismanagement. So I believe that you all have now grasped some considerable knowledge on this particular aspect, and that you are more versatile in the area of what is oppression committed by the directors of a company and what falls within mismanagement. Again, a subject that falls within the purview of the directors who fail to conduct themselves in the proper manner as per expected under the company's law in general. So today I would like to continue from where I stopped last time, and I was explaining to you about how an oppression or mismanagement application could be made to a competent court. Now generally these company matters now fall within the jurisdiction of the Commercial High Court that is specifically set up for the hearing and determination of company matters. The oppression and mismanagement too is an area that falls within the jurisdiction of the Commercial High Court of Colombo, where this Commercial High Court is only based in Colombo in Sri Lanka. So therefore, any action pertaining to the oppression and mismanagement must be instituted in this particular Commercial High Court of Colombo. Now, when such an application has been made and a hearing has been given by the respective court, competent court, now it is a matter for the court to arrive at its decision, whether to see an oppression or mismanagement has occurred or not. So where on any application made under the said provisions, the court is of the opinion that the affairs of a company are being conducted in a manner oppressive to any shareholder or shareholders of the company. Last time I explained to you extensively on what falls within the ambit of oppressive act or oppression. The court here may, with a view to remedying the matters complained of, make such orders as it thinks fit. So the court, if satisfied with the petition that has been presented to the court, complaining of the affairs that have been conducted in an oppressive manner, then in such circumstance the court may refer to the entire matter and thereafter determine what suitable measures or what suitable remedies have to be implemented in order to protect the company or the legal person that represents this company in particular. So when it comes to the order made by a court, the court has a wider array or scope of what can be awarded as relief with the view of protecting and safeguarding this corporate entity. So whatever the court thinks fit, the court can make the or grant the remedies. For example, if the court sees that the particular business affairs of the company have been conducted in an oppressive manner, and a certain transaction has been entered into in a manner which is very oppressive towards the company or to its shareholders, the investors, then the court can discontinue the contract or the transaction, or even it can go to the extent of cancelling or terminating such transaction or the contract that has been entered in a way that it leads to an oppressive manner. So, pending the making of it, of a final order. Now, if the court sees that it may need further adjudication of the matter, and that may extend to some time or some number of hearings, but of course on the face of it, prima facie, it appears that the conduct of the directors have been quite oppressive, and the court is suspicious of the fact that the directors have acted in an oppressive manner, then the court can at first instance grant what you call a restraining order. That is to prevent the directors from acting further in that oppressive manner that would operate in detriment to the particular company. So, the court may, on the application of a party to the proceedings, make an interim order in the nature of a restraining order. So, at first instance, the court can enjoin the acts of the directors so that the company will not suffer from such oppressive acts complained of by the petitioners, that means like the shareholders, so that the act of oppression comes to a standstill until the court finally determines whether or not a real case is proved. So, which it thinks, where the court thinks that it is necessary for regulating the conduct of the company's affairs upon such terms and conditions appear to it to be just and equitable. Now, here the interim relief that the court may grant would be in the nature of a prohibitive type of a remedy, where the court will very specifically allow the interim relief sought for by the petitioners, whereas the directors who are responsible for that will be enjoined from taking any further steps or acting in such manner at future, so that the affairs of the company will be regulated for an interim period by way of providing this interim relief, where the directors so complained against will have to be abide by the court order that they would not act further with the same manner until the final determination by the court. So, this is a kind of an injunctive relief, though we do not call it an injunctive relief in the area of company law, as I mentioned, explained to you last time, but that would prevent the directors from acting further in relation to the act complained of. And the court will always pay attention to the fact that the order that the court makes is just and equitable. So, that is the extent to which the court can extend its powers or go and reach to the extent of the court's action or the order being just and equitable. So, it is fair, reasonable, and that the court will do or the court can do anything to prevent further injustices being caused until it finally decide on the matter. In such event, the court may, in pursuance of section 521, which provides for the granting of injunctive relief or what we call the restraining orders, on the application of the part to the proceedings, make such interim order until the final restraining order is granted, including a restraining order as it thinks fit. So, that would restrain the particular directors against whom the action lies, so that the directors would be enjoined from acting further, as I mentioned previously, pending the making of a final order in an application or reference to court made under this Act, the Companies Act. Such order may, at the discretion of the court, be made ex parte or after notice to the respondent. Now, this is a very important area, because when the petitioners come to court, the petitioners would require the intervention of the court by way of issuing an interim relief for the preventing of further action, and that could be very immediate and urgent. So, in order to be immediate and urgent in preventing those wrongful directors acting in such manner, the court has the power to entertain the petition of the petitioner, such as the shareholder or shareholders, on an ex parte basis, where the petitioner's legal counsel would be allowed to support the matter, seeking an immediate and urgent interim relief being made by the court, and thereafter to proceed by obtaining the particular interim relief, inform the company and its directors not to proceed with such acts complained of, and also they would be notified to appear in court on a given date that falls later. In some circumstances, shareholders do not mind notifying the respondent directors on the day that of the day that the petitioner seeks to support this application or the petition in the court, so as to let the respondent director to state his or her case in defense, and let the court to decide whether there is a matter at moot. So, whatever it is, whether an action is filed seeking an order ex parte or an order upon hearing both parties, the company law allows such application be made and heard in any of these two ways. And thereafter the court to proceed making such interim order likewise. If the other party or the respondent party is present in court at the time of supporting the application or the petition of the petitioner, shareholder or shareholders, there is no reason, there is no need arises to notify the respective respondents aftermath, because the respondents in court will take the notices to represent such directors in the next days to come in this case. The respondent may make an application for an order of revocation or variation of the ex parte order. If an ex parte order has been obtained by the petitioner, when the respondent directors or director is notified of the order, the respondent director or the directors can thereafter come to courts as per the notice the day that the case is to be called next, and be represented by a legal counsel who would object to the granting of the ex parte interim relief. And if the court is satisfied that there is favorable ground on the part of the respondent director, and that the respondent director had not really acted in an oppressive manner, then to revoke or cancel the already granted interim relief and let the respondent to present his case and the court to arrive at the final decision whether to provide a restraining order or not. Practically, this might take some days of hearing in court. Generally, when an ex parte order is obtained, the day that the respondent director has been notified to appear, if the facts are on balance of probability in favor of the respondent, then the court will revoke or cancel the already made interim relief and let the respondent to state his case. Now, in obtaining an ex parte order or an interim relief inter parte in the presence of the respondent director or directors, the petitioner shareholder seeking an injunctive relief like in this nature, in interim relief, must present a prima facie case against the respondents. What do you mean by prima facie case? On the face of the alleged facts and materials that have been tendered before the court should be satisfied that these allegations levelled against the respondent directors are fairly in support of the petitioner. There is no material suppression of facts or circumstances. There is no suppression of documents if it is related to a certain matter that is more connected and correspondent with documents. Then the court will find a prima facie case in favor of the petitioner, and thereafter also the court will require the petitioner to present the case that proves the balance of convenience on the part of the petitioner. That is to say that the petitioner is more fully prejudiced by such acts of the respondent directors, and if such acts of the directors continue, this particular petitioner shareholder or shareholders will further experience loss or damage which are irreparable in nature, not repairable, irreparable. So, first and foremost, in an application by the petitioner shareholder, he or she should present a prima facie case for the court to rely upon the providing of an interim relief, and also that the balance of convenience is in the favor of the petitioner rather than in the favor of the respondent. When the respondent come to court or respondent object to the making of the order, at first instance, if the respondent has been notified and present on the same day that the petitioner support this application, the respondent has the opportunity to present his or her case to show that the petitioner has not exhausted a prima facie case, or it has not exhausted the balance of convenience in his favor, and therefore, say for example, such as where the petitioner has suppressed certain material facts or circumstances, then of course the court will make the order in favor of the respondent director or directors, that is by not allowing or not issuing the interim relief sought for by the petitioner. The court shall not grant a restraining order or any other form of interim order under this act on the application of a shareholder, former shareholder or a director unless the applicant has first lodged with the court an undertaking in writing that if the order is sought is granted and the company or any other person suffers loss or damage which the court considers as just and equitable for the applicant to bear, the applicant will indemnify the company or other person against that loss or damage. Now, this is a very important aspect. While presenting the petition by the petitioner, shareholder or shareholders, the petitioner, shareholder or the shareholders should also give an undertaking to court that in case the petitioner has presented a mala fide in bad faith case, or that the company is going to suffer for a case which is not prima facie could be established, or where the case is not that strong, and that the shareholders, petitioners have come with some wrong interpretation of the affairs. In such a situation, the petitioner, shareholder or shareholders are required to also give an undertaking in the same petition that such petitioners will provide or undertake to provide any loss or damage that these respondent directors or the company will suffer as a result of a bad pleading, a bad case. So, this is a compulsory and foremost requirement that the petitioner undertakes in the petition to remedy any loss or damage that may unduly cause to the company or to the directors who have been made respondents, and only in such circumstance that the court may entertain such application for an interim relief and or restraining order. When the petition lacks such an undertaking, the court may refuse to grant such interim relief or the restraining order, or else when a respondent objects that the petitioner has not given such an undertaking, the court can refuse the entire application on that basis. So, this is very important element in seeking the remedy of the court or the relief. Now, as per section 225 of the Companies Act, any shareholder or shareholders of a company having a complaint that the affairs of the company are being conducted in a manner prejudicial to the interests of the company, or that a material change, not being a change brought about by or in the interest of the creditors, including debenture holders or any class of shareholders of the company, has taken place in the management or control of the company, whether by an alteration in its board of directors or of its agent or secretary, or in constitution or control of the firm or body corporate acting as its agent or secretary, or in the ownership of the shares of the company, or in any other manner whatsoever, and that by reason of such change, it is likely that the affairs of the company may be conducted in a manner prejudicial to the interest of the company, may make an application to court for an order under the provisions of this section. So, whenever the petitioners or petitioner present any of these matters before the court, showing that the company will suffer due to the acts of these directors, then the petitioner can make such an application seeking the prevention of such acts of the respondents by the court, and further to seek an order from the court in pursuance of this particular provision in the Companies Act. So, this is a good opportunity for those who see or fear that the company affairs are conducted in a wrongful manner, that they could go to court and they could prevent the directors from acting so as a matter of safeguarding, protecting the due interest of the legal person, who is not a natural person, who cannot say, I'm wrongfully being victimized, or that I am prejudiced by this, where the petitioner, being the shareholder or shareholders, come to the saving or salvaging of the company in such extreme circumstance where the directors are acting or have acted in such wrongful manner. Where on any application made under the said provisions, the court is of the opinion that the affairs of the company are being conducted as referred to in subsection 1 earlier that we discussed, or that by reason of any material change that is referred to in that subsection in the management or control of the company, it is likely that the affairs of the company will be conducted as aforesaid. The court may, with the view of remedying or preventing the matters complained of or apprehended, make such order as it thinks fit. So, the court has a sheer discretion based on the facts and materials placed before the court. The court can exercise its discretion whether to provide a relief to safeguard the company and the company's interest, or if it thinks that the company interests have not been arbitrarily disturbed, then not to issue such an order. So, here the court has a more subjective as well as objective role to play. Subjectively, the court has to refer to all the statements and facts, materials placed before it, and objectively to refer whether the oppressive act complained of has really occurred in this company. Then only the court can come to a decision to grant the interim relief sought for or final relief of the restraining order and any other subsequent orders that the court may grant in remedying the situation. If the court, while attending to the subjective and objective means, discover and adjudge that nothing wrong has been committed by the director's acts, then it can prevent from granting the interim and or the final restraining order in relation to operation and mismanagement. Pending the making of a final order, the court may, on the application of the party to the proceedings, make an interim order as it thinks fit for regulating the conduct of the company's affairs. As I mentioned, and section 521 will apply to also in respect of the mismanagement as outlined earlier with regard to operation. It's the same way that under 521, the petitioner to give an undertaking that if the company or the directors have been wrongfully affected by the acts of the petitioner in complaining of a mismanagement situation against the administration, such as the directors, then that the petitioner would remedy the loss or damage created by the petitioner in going to court. Next interesting and important area that I would like to discuss today is on another area of filing action when wrong is committed against a company. These type of actions are called derivative actions. Derivative actions. Now, this is different from operation and mismanagement because derivative actions is a different type of an action that are available for different class of petitioners. Now, let us see what is this derivative action all about, who are the ones who are entitled to bring a derivative action, and what sort of remedies are available for the court to grant towards those who have been victimized in the company. Now, in both operation mismanagement area and the derivative action, the court will always look at the interest of the company. Because in the law, even though the court does not intervene or interfere in company's internal affairs or internal management as we have previously observed, the court will always operate as a custodian or the guardian for a company. This is a very important role vested upon a court. Though it does not get involved in the day-to-day activities of a company or companies, in checking whether the company, even being a legal person, not a natural person, of course, an artificial person, would still be prejudiced by the acts of natural people. So, the court operate in both these types of actions as the custodian or the guardian of the artificial person, the corporate entity. Since shareholders are not empowered to control the day-to-day operations of the corporation, we know who are empowered to handle day-to-day activities are the people in the administration headed by the directors. They appoint directors. Shareholders are the ones who appoint directors. We know that. We have covered that area. We know that the shareholders are the real owners of a company, so that they appoint the directors, and the directors in turn appoint officers or executives to manage day-to-day operations from top to bottom, from senior management to the lower management. If those officials commit any act of ultra virus, acting out of scope, as I have previously dealt in detail what this act of ultra virus is all about. So, whenever the officials commit any act of ultra virus, the shareholders could bring a derivative action to correct such acts. So that the difference between oppression and mismanagement and a derivative action is that the oppression or mismanagement area deals against the oppressive or mismanagement elements committed by the management of the company. Derivative actions can even be brought against shareholders by shareholders. So, if acts of ultra virus have been committed, the shareholders could bring a derivative action to correct such acts. If the directors, officers or employees of the corporation are not willing to file an action against some other person, such as a shareholder, who is acting in contrary to the interest of the company, then such shareholder can bring such a derivative action for the sake of protecting the artificial person, the company, as a kind of a protector, where such shareholder may act as a savior of the company and in the interest of the company to protect this artificial person. So, in a derivative action, what is important is that, unlike in the oppression or mismanagement where the complaint act is directed towards the wrongdoer, here in derivative action, the action is based on the interest of protecting the corporate entity. So that the petitioner here comes for the sole interest of the company rather than for himself or herself. So, it is to safeguard the company and protect the interest of the company that the petitioner really files a derivative action. Maybe that there is no personal wrong that has been committed towards this shareholder or the petitioner, but there is some wrong committed to the company, and since the shareholder has interest in the company, the shareholder comes as a protection of the particular artificial person or the company, and correct wrongful acts committed by anyone in the administration or the management or even in the shareholding of the company. If the directors, officers, if they if they are not willing to file an action, a shareholder may first petition them to proceed. But the shareholder comes, as I mentioned to you before, in the interest of the company, not his or her personal interest. So he has to demonstrate that the reason why he is coming before the court is to protect the interest of the company and not for his own personal gain. Therefore, derivative suits permits a shareholder to bring an action in the name of the corporation against the parties allegedly causing harm to the corporation. So, since the petitioner is now representing the interest of the company, in the petition, the petitioner must mention, the shareholder must mention that the petitioner is coming forward as a savior or a protector of the company, so that the petitioner himself or herself is trying to protect the interest of that company. Now here, let me distinguish these two areas regarding oppression or mismanagement. In such a petition, the petitioner complains against a director X in the petitioner's personal interest. In the petitioner's personal interest. In the case of a derivative action, the petitioner here is not representing his or her personal or personality, but petitioner in the interest of XYZ Limited, for example, against maybe we will say person A. It can be director, it can be other, whoever who is committing a wrongful act against the company. And here the petitioner has come in the interest. This is very important. The petition must state that the petitioner is coming forward in the interest of the company. Unlike here, which is a more personal type of a circumstance. So, if such petition fails, the shareholder may take it upon himself to bring an action on behalf of the corporation. Any proceeds of a successful action are awarded to the corporation and not to the individual shareholders that initiate the action. So, since the petitioner comes in the interest of the company, the remedies granted to the petitioner here is towards the company and not towards the petitioner personally. Any proceeds of a successful action are awarded to the corporation and not to the individual shareholders that initiate the action. A lawsuit brought by a shareholder of a corporation on its behalf to enforce or defend a legal right or claim which the corporation has failed to do, then a derivative action, more popularly known as a stockholder action, is available. So it is not for his personal gain, likewise in the operation of mismanagement, but for the interest of the company. Now, let me further distinguish these two with examples how such situations may arise in company matters. Now, in the area of operation of mismanagement, imagine a situation where the petitioner has personally experienced some losses or damage due to a wrongful act of a director. Then more appropriate is a operation of mismanagement case, action. If in a situation where, say, the director board, for example, has removed one director, one good director, and a shareholder of this company finds that removal of such director from the director board would be quite detriment to the existence of the company, so that the petitioner is not affected though, but the company, and therefore it is important for the petitioner to bring an action in this situation against the others for removing that director from the company's director board in the interest of the existence of this company. A derivative action, more popularly known as stockholders' derivative suit, as I mentioned to you, is derived from the primary right of the corporation to seek redress of legal grievances through the court. So it is actually based on the fact that a company, being an artificial person, cannot itself come to court. We know that. So the company needs a support of the natural person who can walk into the court, complain of the alleged act, and seek a remedy also for the artificial person. So therefore, a derivative action is very important in that context. Derivative actions were a construction against the common law case of Foss versus Harbottle. There was a very famous English case called Foss versus Harbottle. What happened here is that there was some mishandling of affairs in the company, and when it was made to the attention of the court refused to intervene in internal management of a company because of the internal management rule. However, in exceptional circumstances, you find the real requirement of a court to intervene in company affairs when irreparable loss or damage caused to the company due to certain acts, and the company is going to suffer now because of this, and the court's intervention into the matter is imperative, which is a step that goes beyond the context of court's non-intervention with the Indo management, but as a matter of protecting this artificial person, the court's inevitable need to look into such matter. According to the rule of Foss versus Harbottle, any action in which a wrong is alleged to have been done to a company, proper claimant is the company itself. Proper claimant is the company itself. But we know that the company cannot come to court by itself because it's an artificial person. So there has to be a natural person who can represent the interest of the company in doing so. The exception to this rule is known as a derivative action. So, as I told you, the exception to the Foss versus Harbottle, where the court denied or refused its intervention into company affairs, internal management, but whenever there is a matter complained of that the company is going to suffer, the court is eligible to enter into this. This is where the exception rule comes into play. Exception to the Foss versus Harbottle rule. This allows a minority shareholder to bring a claim on behalf of the company as a wrongdoer control and is in reality the only true exception to the rule. So, a derivative action is something that affords benefit to a minority shareholder who sees that the majority that controls a company is acting in the detriment of the interest of the company. Then the minority shareholder can seek remedies from court by way of a derivative action. The rule in Foss versus Harbottle is best seen as the starting point for minority shareholder remedies, because it provides, or rather the court is able to take a further step and find out exceptional ground on which the court can intervene in the internal management of a company, that is not restricting to the Foss versus Harbottle decision. Now, what happened in this Foss versus Harbottle? First and foremost, Richard Foss and Edward Starkey Turton were two minority shareholders in the Victoria Park Company. The company had been set up in September 1835 to buy 180 acres of land near Manchester, and according to the report that led to the buying of this property, according to that report, enclosing and planting the same in an ornamental and park-like manner, and erecting houses thereon with attached gardens and pleasure grounds, and selling, letting, and otherwise disposing thereof. So that was the purpose for which they wanted to invest. This became Victoria Park, Manchester. Subsequently, an Act of Parliament incorporated the company. The Victoria Park, Manchester was the company. The claimants alleged that the property of the company had been misapplied and wasted, and various mortgages were given improperly over the company's property. The main purpose for which the property was to be bought is to make the gardens and a nice living for people seeking some kind of apartments and so forth, and also to provide some leisure opportunity in that 180 acre land. But what happened really in this company is that the particular property was misapplied. It wasn't developed in such a manner. This particular property was mortgaged for money and various other activities that fell outside the main objectives of creating the company were quite apparent and visible. They asked that the guilty parties be held accountable to the company, those who misused or misapplied the property be accountable to the company, and that a receiver be appointed so that the receiver could recover whatever he could and either continue with the company affairs or to close down the company whose property, this main important property, was misapplied wrongfully. The defendants were the 5 company directors: Thomas Harbottle, Joseph Atchett, Henry Byron, John Wested, Richard Bailey, and the solicitors and architects Joseph Denison, Thomas Bunting and Richard Lane, who were involved in the designing part and also the legal matters. And also R. H. Rotten, E. Lloyd, T. Pett, J. Biggs and S. Brooks, and several assignees of Byron, Atchett and Wested, the company that owned this land, who had become bankrupt. The company now has become bankrupt because of the misapplication of this company's sole property that was purchased by the company to create such environment as I mentioned. Vikram VC, the Vice Chancellor of the Court, House of Lords, dismissed the claim and held that that when a company is wrong by its directors, it is only the company that has standing to sue. The court saw that if the company has been prejudiced by way of such wrongful act, it is the company that has the action against the perpetrators. So the company has to come to court. Now there is no rationale. How can an artificial person walks into a court or to petition the court? It is obviously impractical. In effect, the court established 2 rules. By underlining the cardinal principle that when a corporate entity is prejudiced or wrong, since the company cannot come by itself to the court as it's an artificial person, then the court constructed 2 rules. Firstly, the proper plaintiff rule is that a wrong done to the company may be vindicated by the company alone. So by way of proper plaintiff, who is the proper plaintiff? It is the company that has to complain the purported act. So the proper plaintiff is the company, and further it went on to say, secondly, the majority rule principle states that if alleged wrong can be confirmed or ratified by a simple majority of members in general, then the court will not interfere. That means that if the majority can rectify or ratify whatever wrong to be made good, then the court may not need to look into this matter. But taking into first consideration the first element, where the proper principle, proper plaintiff concept, then since the company cannot come, though the Foss versus Harbottle case said so, that the company has to come, then we see that there is some defect in this ruling. That's why the court in later instances kept a foot further and said that the company cannot come here. Therefore, we must let somebody who has the interest for the company to come on behalf of the company and safeguard that proper plaintiff. So the Foss versus Harbottle case decision was truly debated in every corner of the justice and legal system, stating that the decision was wrong, that how can an artificial person walks into a court? How can an artificial person files an action when it has suffered such loss or damage? There has to be some kind of mechanism or modality that has to be adopted so as to enable the artificial person be protected. So, further then future courts allow the proper plaintiff principle to be applied within the concept of some kind of a custodian who will come for the saving of that artificial person in the way of a guardian or custodian who will act on behalf of such a artificial person. The rule was later extended to cover cases where what is complained of is some internal irregularity in the operation of a company. However, the internal irregularity must be capable of being confirmed, sanctioned by majority. Where the majority could sanction or confirm such a irregularity that exists within a company. A shareholder cannot generally bring a claim to recover any reflective loss, a diminution in the value of his or her shares, in circumstances where the diminution arises because the company has suffered an actionable loss. The proper course is for the company to bring the action and recoup the loss, with the consequence that the value of the shares will be restored. So, now the court tend to think proper plaintiff principle, under proper plaintiff principle the company must come, but since the company is an artificial person, now the court is constructing some further elements enabling the company interests be safeguarded. Because Foss versus Harbottles leaves the minority in an unprotected position, exceptions have arisen now. The courts have constructed new rules that can deviate from the Foss versus Harbottle rule, so that the courts do not have to rely upon the Foss versus Harbottle, but in special circumstances where the court has authority to move in to a different aspect and thus provide a wronged company or an affected company to remedy itself, then statutory provisions have come into being which provide some protection for the minority that are affected. Because otherwise the majority rule will exist and the majority will always suppress the minority. By far and away the most important protection is the unfair prejudice action. At that time in UK, sections 994 to 6 of the Present Companies Act 2006 UK and the Corporation Act 2001. Also there is new statutory derivative action available under the sections of 260 to 269 of the Present Companies Act in UK 2006, and also in Australia under section 236 Corporations Act 2001, that would remedy the Foss versus Harbottle rule and allow this type of a incident where anyone who has an interest in the company can come to court on behalf of the company in order to protect the interest of the company and sue against the wrongdoer, so that a new statutory provision was included in the company law to overcome the barriers set up in the Foss versus Harbottle in common law courts, the common law case. Now, correspondently, Sri Lanka also has made similar statutory provisions inclusions in our Companies Act. Now, before we discuss the Sri Lanka statutory provisions in regard to derivative actions, let me further go into the area of clarifying how we could distinguish the Foss versus Harbottle, or we could deviate from the Foss versus Harbottle case law.
These said exceptions to the rules in Foss versus Harbottle arise where litigation will be allowed. The following exceptions protect basic minority rights which are necessary to protect regardless of the majority's vote. They include where an act of ultra vires or illegality has occurred in the company, such as in the nature of the directors of a company or shareholding majority may not use their control of the company to paper over actions which would be ultra vires the company or illegal. Secondly, actions requiring a special majority. If some special voting procedure would be necessary under the company's constitution or under the Companies Act, it would defeat both if that could be sidesteps by ordinary resolution of a simple majority and no redress for aggrieved minority be allowed. Now, for example, in the case of an amalgamation that we will be learning later on, you need to have a special resolution passed. An ordinary resolution will not make an amalgamation of companies together. Since the matter is a very important and of high necessity to be discussed and passed by way of a special resolution. So, if such a thing has not occurred, then it paves way for the minorities to seek protection of its rights by way of a derivative action. And then also the other circumstances where there was an invasion of individual rights. If the majority has taken over the minority at some point of juncture, then the minority will have a right to obtain redress from court. And frauds of the minority rights, fraud in the context of derivative action means abuse of power whereby the directors or majority who are in control of the company secure a benefit at the expense of the company. So whereas the minority rights are so suppressed, the minority rights are so pushed to unnotable circumstance. Now, as per section 234 of the Companies Act in Sri Lanka, as I mentioned earlier, these statutory provisions are brought in our company law, and you can see in section 34, the court may, on the application of a shareholder or director of a company. Now, whereas here it was always a shareholder, but here it could either be a shareholder or a director, being the petitioner, to bring proceedings in the name and on behalf of the company or any subsidiary of the company in the interest. This is what it says, on behalf of the company, or intervene in ongoing proceedings to which the company or any subsidiary is a party for the purpose of continuing, defending or discontinuing the proceedings on behalf of the company or subsidiary as the case may be. In two circumstances, such a shareholder or director can bring in the intervention of the seek intervention of the court. In determining whether to grant or not grant leave under that subsection, the court shall have regard to the likelihood of the proceeding succeed. So now in a derivative action, first and foremost, when a derivative action is instituted in the court must first look at the circumstance. The court must look at the scenario that has occurred and thereafter must allow the petitioner to proceed. So what is required first and foremost is the leave of the court, the permission of the court to proceed with such action. So when a derivative action is filed, it does not mean that the petitioner as of right has an actionable claim, even on behalf of a company. The court first of all must be satisfied that there is an important cause that has arisen for it to intervene. This is because the court is going beyond the internal management rule. So the court must be satisfied and then the court gives the leave if satisfied. Otherwise the court can reject. If the court rejects, the entire derivative action is gone. Or intervene, so the court will look at the likelihood of the proceeding succeeding, whether there is a case. That's number one. And then the cost of the proceedings in relation to the relief likely to be obtained. The cost of the proceedings, because this petitioner is coming in the interest of the company. Whether the court is enabled now to provide the cost for the petitioner who is now moving for a remedy in the case. And any action already taken by the company or subsidiary to obtain relief, any internal relief that the company may have taken in offsetting loss or damage complained of. The interest of the company or subsidiary in the proceedings being commenced. The interest of the company or subsidiary, whether the petitioner really is coming to the court in the interest of protecting, with the motive of protecting the interest of the company. Relief, continue defendant or discontinued as the case may be in any of the matter. So when a derivative action is instituted, the first thing what the petitioner must obtain is the leave of the court. So in the petition, in the petition, as a prayer, the first thing that the petitioner must seek is leave to proceed. Leave to proceed. This is what the court has to first give. The second, third, fourth, whatever could be any other relief, the exact relief that the petitioner seeks to restore the lost dignity, the loss, financial loss or damage caused, all these things, and thereafter maybe to remove a director or the wrongdoer, whoever, can be sought. But the first thing is that it must seek the leave to proceed from the court. Leave to bring proceedings to or intervene in proceedings may be granted only if the court is satisfied that either the company or subsidiary does not intend to bring, diligently continue, defend or discontinue the proceedings as the case may be. That means the court has to be satisfied that no other internal management person will bring this action. And B, or it is in the interest of the company or subsidiary that the conduct of the proceedings should not be left to the directors or to the determination of the shareholders as a whole, but let a minority shareholder, for example, come for the sole protection of the company's interest. Except as provided for in this section, a shareholder or director of a company is not entitled to bring or intervene any proceedings in the name or on behalf of the company or subsidiary of the company. So, unless an action is brought in this way, no other way that a director, shareholder or whoever, major or minor shareholder, eligible to bring an action of this nature. So it has to be by showing first and foremostly the interest that the petitioner has on the company to bring such action. So the petitioner is coming in the interest of the artificial person. The court may, on the application of a shareholder or director to whom leave is granted under section 234 to bring or intervene in proceedings, order that the whole or part of the reasonable cost of intervene in the proceedings, including any cost relating to any settlement, compromise or discontinue approved, shall be met by the company. So the court, once it is seized with such an action, may look into the company's financial aspect and determine whether the cost of this case can be met by the company, because it is the company's interest for which the petition is coming. So the petition is not expected to spend by himself or herself. It is the company that has to spend, because the petition is coming for the interest of the company. That's the reason. No proceedings brought by a shareholder or director, or in which shareholder or a director intervenes, as the case may be, with leave of the court under section 234, the main section dealing with derivative action, may be settled or compromised or discontinued without the approval of the court. So interestingly, no out of court settlement in settling this case be made unless making the court aware of such compromise or settlement, and such settlement or compromise should be brought to the attention of the court, where the court will thereafter take connivance of the fact and allow the parties to settle or compromise. If the settlement or the compromise is towards the interest of this artificial person, the company, the court may at any time make any order or it thinks fit in relation to any proceedings brought by a shareholder or director, with leave of the court under section 234 and without limiting the generality of the powers conferred under this section. Thereafter, what are now the remedies that the court can provide? The remedies that the court can provide. The petitioner may have prayed for these. Firstly, if the court is satisfied to grant leave to proceed, thereafter the court will hear and determine the action and then see whether these other remedies can be granted. Among which the court can grant would include make an order authorizing the shareholder or any other person to control the conduct of the proceedings, It's out of the leave to proceed. Subsequently, give directions for the conduct of the proceedings, make an order requiring the company or directors to provide information or assistance in relation to the proceedings, or make an order directing that any amount ordered to be paid by a defendant in the proceedings shall be paid in whole or in part to the former and present shareholders of the company or subsidiary instead of the company, or to the subsidiary as the case may be. So those are the main things that we discussed about the operation and mismanagement, which are very important elements of our important actions that fall under the company's law purview and context. Now I would like to take you through the area of amalgamation, mergers, acquisition and takeover. Nowadays, many companies are facing takeovers, mergers, acquisitions and so forth when a particular company or companies are commercially viable and doing well. If a company is doing well, then an investor may come into the picture with the view of acquiring that company and taking over that company affairs or the personality of a like kind of an investment process with the view of profiting. So mergers and acquisitions are areas that are highly or extremely demanding right now. As company secretaries or accountants or whoever, lawyers, their services are required in this process very much in order to take forward these companies with the view of profiting and to higher levels of existence. Mergers and acquisitions form a very important part of corporate finance. It's a kind of a financial strategy because anyone would be interested in acquiring or investing in companies that grow. So, as accountants, the accountants of a company or the auditors play a much larger role here in presenting a more viable and entertaining type of a financial status, stability of a company. So that's why it's a part of corporate finance. When a company takes over another company and clearly establishes itself
as the new owner, it is called an acquisition. So when a company is taken over by new set of investors or an investor, it is a takeover. This can be done for a wide number of reasons, ranging from a large company planning to expand its operations into a field of well dealt with a smaller company it can afford to obtain, to a business procuring a failing firm as they think that it has some amount of value to them. There are different types of success stories in the corporate world. If you do case studies, you will find that the companies in Sri Lanka may have in the past have performed well and they have been acquired by new investors who take such companies to much higher levels of performance. There are some kind of companies that one or two substituent arms of such companies have been doing well more than the holding company or a much bigger company of it. Now, let us see situations where there is a company A. Company A was formed, say, in 1972. Then company A has further created a subsidiary called company B, and it has been created in 1980. But the company B is doing much better than company A. Then company B has maybe created company C in 1995, and it is doing much even better than company B. This is one example I have taken. Then there may be an investor called X who wishes to invest or take over company C because the particular investor X see that the company C is doing well and there is good opportunity to acquire company C. So that when it is acquired by X, this connection is detached. So the company C goes out. There are several classic examples in Sri Lanka that have happened. You see, here the holding company that has created subsidiary, but still this subsidiary is doing much better than the holding company or another subsidiary. Because of the business viability, the growth that this company is more potential with, this company could be very easily taken over by an investor. Or sometimes there may also be situations in a different type of a setup that company A has been created in 1972, company B like 1980, company C, the same example I am taking, in 1995, and there is another company created D which is much smaller than anyone else that has been created in 2005. But the potentials of growing for D is much bigger, and that acquiring company D by X to be more attracted, that in the year, by the year 2020, company D has grown into much bigger corporate structure or corporate entity as a business element is much stronger and inflated in business. So these kinds of decision makings are very, very diversified. It all depends on what the investors are really looking at. Some may prefer to purchase a big company, some may prefer to purchase a small company with the intention of making it a bigger company. There are also, in the second type of situation, there are also companies in Sri Lanka that have grown from scratch to a huge enterprise. Several examples. So, whatever it is, the acquisitions will take effect based on different economic circumstances. Mergers, on the other hand, mergers where company A in 1970 and a company B that has been created in 1971 has been merged together in the year 2020. Merged together. Either they exist separately or they exist as one, whatever way. But in the company register, there will be an amalgamation. There will be an amalgamation. There will be an amalgamation. These kinds of amalgamations have happened very much in the banking industry in Sri Lanka, where one bank has merged with another bank and they have a different name now presently, right, and perform as a much bigger entity. Now, say for example, I will say Hong Kong Bank and Shanghai Bank have merged together and amalgamated. These have been in the company register as separate institutions and now being amalgamated in the later registry as Hong Kong and Shanghai Banking Corporation, for example. So that there is a amalgamation that has taken place. This is called the mergers. Mergers, on the other hand, are situations where two companies decide to form a new company. A big concern in these cases is fair treatment of employees and ensuring that nobody with a stake in either company is ousted against their will or treated unfairly. So, these things actually take place with an economic type of a decision making. The rationale behind a merger could be various, such as to make profits, more profits, such as to give equal treatment to the employees of the two companies, or to the customers, fair deal. Different types of rationales may be behind such amalgamations or mergers. Now, in our law, under section 239, two or more companies may amalgamate and continue as one company, which may be one of the amalgamating companies or may be a new company. As I told you, either they remain separately but amalgamated, or they form a new company upon amalgamation and take a new company name. Public notice of such amalgamation shall be given in accordance with the provisions of this Act. So, first and foremostly, when the two companies are amalgamated, you need to enter in the company register the form leading to the amalgamation. So, there is a separate format that is to be tendered to the register of companies, and that will disclose the fact that these two companies have been amalgamated as one. Either it will be amalgamated and remain in two names, or there is a third company created due to the amalgamation with one single name. There is a specific format, Form 7, in the register of companies that issues for a new amalgamated company. Now, if we look at the philosophical and economic concepts of amalgamations or acquisitions or whatever, takeovers, there are numerous legal issues to consider in the process of an acquisition or a merger, which may occur at any stage. These include conducting due diligence, because it is very important that the company to be amalgamated or to be acquired is properly taken through a due diligence process. That is to find out the pros and cons, the pluses and minuses, what are the advantages and disadvantages, what are the opportunities and what are the strengths, weaknesses and threats, like the SWOTs, conduct all these things. And also the litigations that a company may have. So, all kinds of financial stabilities, all these things have to be well taken care of by a proper due diligence process. Conducting the due diligence, that is the process of acting on all of the liabilities associated with the purchase of the new business, as well as verifying that all the claims made by the vendors are correct. In such process, the directors of the companies are responsible for the carrying these out. For legal purposes, it is important that one must obtain details of past, current or pending legal cases, as well as proof of the targeted business owns key assets such as property, equipment, copyright and patents. It is also important to look into the business's employment in terms of current and future contract obligations, as well as contracts that may concern changes in ownership. The same should go for the suppliers to the company. And the second element is the making the deal. Now, when the company A is going to merge with company B, or company A is going to acquire company B, or an investor is going to acquire a company, then in that case, the making the deal is another important process, because there is a demand scenario, there is a bargaining process, then it may have different types of consultations, different number of meetings to decide on the acquisition, merger or creating of the new company, looking at the assets, liabilities, legal matters, all these things. So, making the deal is a process. When considering the terms of the deal, one should seek certain confirmation and commitments from the person or people who are selling the business to make the buyer feel comfortable with the deal, and the former give enough assurance to go ahead with it. Because no investor will ever want to invest in a shrinking company. Any investor, even without considerable or average knowledge of business, would not want to invest in a shrinking company. They all want to invest in growing circumstances. So, therefore, taking this decision is very important, making the deal. The seller will provide assurance in writing which is known as warranty, which may also be required by the business's assets. Order book employees, legal claims and audited accounts, debtors and creditors of the company. It is also important to know that the seller can fully reimburse the buyer in certain situations which are called indemnity. So all these things are to be well taken care of in the process of acquisition, takeover, or the amalgamation or merger process. So these are the very important economic and philosophical things that one must employ prior to taking of the final decision to merge or acquire. Some have even gone to the extent of a final position of acquiring or merging, but they have walked out. That is because even at the final stage, they have come to know of certain unfavorable situation that exists in that business. Now, as per section 241, an amalgamation proposal setting out the terms of the amalgamation and in particular. So, under section 241, an amalgamation proposal should be presented, setting out the terms of amalgamation and in particular the name of the amalgamated company. The name of the amalgamated company. If it is the same as the name of one of the amalgamating companies, then they have to specifically mention it. Because some, like company A, may have a better name in the market than company B. So in that case, rather than going for a new name, the investor might like to absorb company B to company A and leave the company A as it is. That is also an amalgamation, but will not have the same name, will not have a new name. It all depends on what the investor would like to do. Then the registered office of the amalgamated company, not any of the former, but if it remains in one of these companies, still they have to mention what is the address of the amalgamated company. The full name and residential address of each of the directors of the amalgamated company, make sure this, not the former companies, the amalgamated company. It could be of the former companies, but still you have to provide the details of and in relation to the amalgamated company. Specifying the number of shares of the company, the rights and privileges, limitations and conditions attached to each share of the company if different from original types of shareholding. The manner in which the shares of each amalgamating company are to be convened into shares of the amalgamated company. If shares of an amalgamating company are not to be converted into shares of the amalgamated company, any consideration that the holders of those shares are to receive in place of the shares of the amalgamated company. Any payment to be made to a shareholder or director of an amalgamating company, other than a payment of the kind described in paragraph G. Details of any arrangement necessary to complete the amalgamation and to provide for the subsequent management and operation of the amalgamated company. The date on which the amalgamation is intended to become effective. So all these things, though have been restated in former companies, must be restated even if they are same or new, whatever. The amalgamation company is a new company, and these particulars as per a new company have to be tendered. And the company name for an amalgamated company would also revert back to the area of company name provisions, laws relating to company names, because it cannot have, the new amalgamated company cannot have the company name of an existing company other than of one of the one of the former companies that is sought to come into the amalgamation. So with that, I think I conclude today's lecture, and I will be further proceeding with some finer areas of amalgamation, and thereafter in the winding up of companies, which I would have extended lecture since the area is quite large. So until we meet with those areas in this lecture series, I wish to thank you all for listening, and I do hope, as every time, that you have now gathered some very good understanding and knowledge of the company law of Sri Lanka under the CL4 corporate law area. Thank you very much.